Thanks, Philip, for having me, and thanks everyone for joining us. I know it's probably an adjustment going to this webinar format, but we'll make do. This is the first time I've ever presented through a webinar type format. So I guess the silver lining though is it's the first time I get to present in sweatpants as well. But anyway, I hope everyone's doing okay, surviving this, and let's hope it ends sooner rather than later. But in the meantime, yeah, we'll do these by webinar, as Philip said, and we'll kick it off with some intellectual property stuff. So just a little bit about myself briefly. I don't want to take too much of the time talking about this, but I'm a patent attorney. I do patents, trademarks, copyrights, the whole gamut of IP. I work at a local firm called Entralta. We're just a small firm in Orange County here. We're actually what you would call a virtual law firm, in that we don't have like a central office, but instead we just work out of respective home offices. So if we need to meet with a client, where I can meet at the Cal State Fullerton Startup Incubator in Placentia or in Irvine, or I could meet clients at their offices, or we could meet at a Starbucks, or whatever is most convenient for the clients is kind of how we work. But by not having that physical office, we kind of keep our overhead down. We're able to keep our costs competitive and reasonable for our clients. And so because of that, we cater primarily to startups. We like to run lean and mean just like our clients. Currently, there's 3 attorneys in my firm. We each have different backgrounds, and we all have 10 plus years experience. So the managing partner has 25 plus years. I've got about 14 now in IP. My background specifically is computer software, though I handle the firm's mechanical devices, medical devices, really anything you would consider like high tech. I also handle all the firm's trademark work and copyright work. And so another thing that sets us apart, as you see here, we don't have paralegals or junior associates. So when a client hires us, they work directly with us. They don't get handed off to a junior associate, which oftentimes happens when you go to mid-size or larger firms. You're paying top dollar for low quality work product in most cases. But again, with us, we're all seasoned professionals, and you're working directly with us. The one thing that we don't handle is litigation, but we do handle basically everything else. So we're helping our clients identify what IP they have. We help them protect that IP through filing patent and trademark applications and what have you. We help them monetize that IP, whether it's through helping them with licensing agreements. We will send cease and desist letters and negotiate settlements. We'll respond to cease and desist letters, but if push comes to shove and a lawsuit has to be filed, that's kind of where we just hand it off to an actual litigation firm. But again, the whole gamut of IP and things that kind of are IP adjacent as well, sometimes we'll assist with, whether it's kind of business related issues, things like that. But if there's something that a client needs that I don't specifically handle myself, I do have a network of attorneys I know personally in other firms that I always just hand off or refer clients to when they need things other than IP related assistance. And that includes IP litigation. I know some local litigators that charge relatively reasonable rates for that type of stuff. So bottom line is we provide cost-effective, competitive, flat fee prices to our clients for various tasks. So that's another thing that sets us apart is we don't do hourly billing. We don't bill for phone calls or emails. It's just a client comes to us with a project. They let us know what they need done. We then quote them a flat fee for that task, and that's what they pay, no more, no less. And so clients tend to like that arrangement. But so yeah, going back to the virtual thing though, in what we're currently dealing with the lockdown and everything else, or people working from home, we've been largely unaffected as far as our day-to-day operations, because I work from home again on a regular basis. So whereas most other firms are scrambling right now to try to get that infrastructure up and running to allow their attorneys to work from home, we're already doing it, and we have experience doing it. So there's really no hiccups in the service or the quality. Yeah, that's a little bit about our firm. So what we'll cover today is kind of, I'm going to try to give you a general overview of everything as far as what is intellectual property, the four main types of intellectual property. We'll touch on how IP rights are typically owned and monetized. And then after kind of giving you that background, that foundational knowledge, I'll just talk briefly about the 5 most common startup mistakes that I often see. And then also just some questions to keep in mind as you are engaging in your own business endeavors. So as far as questions go, again, I'm used to giving this presentation live or in person where people can just kind of raise their hands as I'm talking, because we will cover quite a bit. I would prefer, and if you're okay with it, feel free to just raise your questions as you might have them. So if we're talking about patents and you have a patent related question, feel free to ask at that point. And since there's only, it looks like about 14 of us, just feel free to unmute yourself, let me know you have a question, and just interrupt me at any point. If there are any people that want to save their questions at the end, I'm happy to answer them at the end as well. Whether you want to say them over the computer verbally, or if you just want to type it in the chat window, either way, I'll be happy to answer them. And if you have any more fact-specific questions, like if you've already developed something and you want to kind of get a better idea of whether your idea is protectable, I'm happy to have those conversations offline as well. My contact info is in the slide deck, and that'll get distributed to you. So you're always welcome to call me or email me, and we can have a more fact-specific conversation about what you're developing. So yeah, but again, as questions come up, just feel free to unmute and ask your question. So first, what is intellectual property? So in a nutshell, intellectual property is essentially the collection of rights that you have in what we would call the work product of your mind. So basically anything that you might come up with is potentially protectable as one form of intellectual property or another. So common examples would be like your inventions, which would be like protected by patents, trade names and symbols, in other words, trademarks, any literary, artistic, or musical works or other creative expressions, which would be copyright, and then any competitively advantageous secrets as well, which we refer to as trade secrets. Any of all that is potentially protectable, again, as in one form of IP or another. An important thing to keep in mind is while all this stuff is intangible, again, these are things you're just creating, that you're thinking up. Even though it's intangible, this IP is freely transferable like any tangible asset. So in other words, when you go to sell your business, for example, once or some of the assets that you typically would include in that sale would be the intellectual property. So you're not just selling your building and your tangible assets, whether it's computers and other equipment, but also the intangible stuff as well. At the very least, typically it's going to be the business name and the goodwill that goes along with that business name, as far as your customer base and that consumer recognition that you have in your trademark in that case. But if you're a technology company, you potentially would be selling the patents and the other kind of IP that's covering the technology. Maybe there's trade secrets involved as well. So just keep that in mind, that these intangible assets add a lot to your business because of typically that that value there that you could transfer to someone else, either through an outright sale or licensing, which we'll get into in a little bit. So another common question is, why protect your IP? Why go through the trouble or the process? The short answer is that properly protected intellectual property gives your company a competitive advantage, because that, and in turn, that competitive advantage makes your company more attractive, typically for potential investment opportunities or licensing or acquisition as well, because that IP is basically giving your company some exclusivity, meaning that others in your industry or could not do exactly what you're doing. If you have, let's say, a patent on the technology that you're taking to market, competitors could not copy that technology, the patented portions at least. So it gives you that edge on your competitors. It gives you that exclusivity, and in turn, that's going to increase the value in your business. And most investors, or licensors, or even purchasers won't pay you for technology that's not protected, because if it's not protected properly, they know that competitors can and will just copy what you're doing. And so why would they pay you anything when there is no exclusivity there, when there's no return on investment, let's say, guaranteed if they're investing in your company, but tomorrow your competitor can do the same exact thing and take your market share. So having that exclusivity, again, is going to increase that value. And if you are looking to talk to investors, a lot of times they won't even talk to you unless you've got this patent pending status, meaning you've filed a patent application on whatever technology you're developing. So that's another reason to at least consider taking the necessary steps to protect at least your most important IP. And again, that's something else we'll talk about. So before you can protect your intellectual property, you have to know exactly what you have and what can be monetized. And again, that's typically something an attorney can help you with. And the other thing to always remember is before you monetize your IP, before you take your stuff to market, you also want to make sure that you're not going to infringe someone else's rights. So you always have to remember that other side of the coin before you take something to market, regardless of whether you might be able to protect your IP or not. Make sure that you're not going to infringe someone else's rights. So the four main types of IP that we'll talk about, they are, as you see, patents, trademarks, copyrights, and trade secrets. We'll get into detail on each of these, but in short, patents basically protect concepts or sometimes implementations of concepts. So in other words, inventions. Trademarks protect the source identifiers that you might use when you take your products or services to market. So that the brand names, let's say, that are placed on these products and services when they're taken to market, those are trademarks. Copyrights, while patents protect ideas, copyrights protect expressions of ideas, or more often than not, creative expressions. So again, that's where your books, your music, artwork, things like that are oftentimes going to be protected through copyright. And trade secrets is basically any confidential information you have within your company that has value could be protected as a trade secret. So the big one that we'll talk about first is patents. Basically, a patent is a set of exclusive rights in an invention that's given to you for a limited period of time in exchange for a disclosure of that invention. So in other words, a government, let's say the United States, in exchange for you disclosing how to make and use your invention, if your invention is sufficiently unique, they're going to give you a patent, or this limited exclusive right with respect to that invention. The whole purpose behind the patent system is it's intended to promote innovation and sharing of information so as to further that innovation, meaning that let's say you develop this great widget, you teach how to make and use that widget in your patent application. Eventually that application or that patent is going to be publicly accessible. And then once your patent expires, the thought is that whether it's your competitors or you yourself or just other people out there could use that quote unquote instruction manual or the information in your patent to make the next best version of that product or that technology. And so it's encouraging you to disclose these details so that the rest of the world can then take that information and build upon it. And again, the incentive for that disclosure is you get this limited period of time where you're the only one that could make, use, and sell this technology, or you have the rights to exclude others, basically. And that's really the rights that a patent gives you, is not necessarily a right to go to market or a right to sell or anything else, but a right to prevent others from doing that without your permission. So specifically what a patent gives you is the right to exclude or prevent others from making, using, selling, offering for sale, or even importing infringing goods and services into whatever country you have that patent. So in other words, if you have a patent in the United States, you're going to be able to stop any infringing activities that take place in the United States. So that could include, let's say somebody makes a knockoff in China and then tries to import it into the United States. If they do import it into the US, they would be liable for patent infringement based on your US patent. Now, obviously, you can get patents in any other country as well. And so depending on the technology and a client's budget, we would figure out the best strategy as far as beyond the United States where other patents might make sense. So for example, if you are selling hard goods and those hard goods might be manufactured by competitors in China, you might consider getting a patent in China as well to kind of cut the knockoffs off at their source. And so there's different strategies. Again, it really just comes down to a client's budget as far as where you would file. But for most businesses, for most of our clients, the US is going to be one of the key countries to get protection in. Beyond that, clients oftentimes consider Europe, but it just depends on where your big markets are, and also again where knockoffs might be made if we're talking hard goods. But at the very least, even if you only get a US patent, again, you're going to be able to prevent people from even importing infringing goods into the country. So as you can appreciate, then that exclusivity gives you quite a bit of value to your company, both for keeping your competitors at bay by preventing them from doing exactly what you're doing, and also then to attract those potential investors or licensees or purchasers by being able to tout this exclusivity that you would have, and that they would be able to invest in or purchase from you or license. But an important thing to keep in mind is a patent is not a grant of permission to take your product or service to market. So I hear this a lot where someone tells me, well, I have a patent on my product, so now I can take this to market and I'm not going to worry about infringing anybody. Or other times a client will come to me where they've already gotten a cease and desist letter, and they think that, well, my product's patented, so I can't be infringing this other person's patent. And unfortunately, that's not true, because basically, even if you have a patent, your product or service might incorporate a feature that's already been patented by someone else. So if there's some small subcomponent, let's say in your device, that's already patented by somebody else, you can't take that subcomponent to market, even as part of your invention, without that other patent owner's permission. So again, as I mentioned earlier, that's always something that you have to look into, is not just whether you can protect your products, your services, but also whether your products or services might infringe, or some aspect of your products or services might infringe someone else's prior rights. And that there are ways to kind of do that type of research. It's what we call a freedom to operate search. So it's always something worth considering before you take something to market. So again, yeah, very important to remember, a patent is not a grant of permission to take your product or service to market, nor do you need a patent. And that's something, another misconception is, sometimes people think that you can't actually take something to market without getting a patent on it first. But there's a lot of products out there that aren't patented, whether they just, the inventor or the creator just didn't want to spend the money on getting a patent if they didn't think it was important enough to pursue. Some things just aren't unique enough to be eligible for patent protection, what you would call like a commodity item. So you don't have to have a patent to take something to market, but certainly if you develop something that's potentially patentable, it's worth considering, as I said before, because of that exclusivity that a patent would give you. And certainly if you're a startup looking to get investors on board, protecting that exclusivity is going to give you significantly more value for investors and for that valuation and to get that interest. So as I kind of alluded to already, these rights are country specific. So again, if you want to get a patent in the US, you got to file an application in the US. If you want to get a patent in Europe, you have to file an application in Europe. I'm not going to get too far off into the weeds on that topic, but I will say that there are ways to kind of string these applications together, where as long as you file your US application first, there are kind of windows of time within which you can subsequently file in other countries. And those applications would all be backdated and given the same filing date as your US application. It's what we call a priority claim. And so it's all kind of case by case as far as a specific strategy we might take for pursuing international patents. But just know that it is possible to file those kind of in succession rather than all at once. So there's ways to defer the costs and the decisions and all that. But again, the key is to at least consider the US, and we'll talk about the timing of that here in a minute. So as far as what's the standards of patentability, we'll kind of touch briefly on those. So first and foremost, there's this threshold issue that in order to be considered for patent protection, the Patent Office first looks to see whether your invention comprises what we call patentable subject matter. Basically, as you can see here on this list, I mean, it's really almost anything under the sun is potentially patentable. So that includes processes or methods, machines, articles of manufacture, compositions of matter, or any improvements on those things. So it's not required that you come up with something completely brand new, but if you've come up with an improvement on something that's already existing, and that improvement is significant enough, then you could potentially get a patent on that improvement. So if you come up with the next best chair or anything else, that you might be able to get a patent on those improvements that you've developed. So the list of what's not is not patentable is a lot shorter than what is patentable, and they're kind of obvious things like laws of nature are not patentable because you don't invent laws of nature. You might discover them, but you don't invent them, so you can't get a patent on something you don't invent. Same thing with natural phenomena. And the third one is what we call abstract ideas. So basically, if your concept is not sufficiently fleshed out as far as a concrete implementation, then oftentimes it might be considered an abstract idea, and so too abstract to be patentable. Now, I could spend a whole separate presentation on this concept of abstract ideas, and particularly this is an issue that comes up with respect to software-based inventions. So all I'll say is that if you've heard things like you can't get patents on software anymore, or if you've heard of this case called Alice v. CLS Bank that came out a few years ago, that was a Supreme Court ruling, it certainly made getting software patents a little trickier, but they are still possible. Particularly the more technical your software is, the greater the chances are that you'd be able to get a patent on some aspects, as opposed to a simpler like app that does something that's already being commonly done and using other means rather than software, let's say. Those types of software-based inventions are a little more difficult to get patents on. But bottom line is that that's something where when a client comes to me with what they've developed, I can give a pretty good idea or opinion on whether I think it's got a chance of being patentable or not. So in other words, clients typically aren't going to have to spend the money on filing an application and wait to see if it's going to get rejected or not to learn whether it's going to be run into this patentable subject matter issue. I'm able to, during that initial consultation, usually figure out whether that's going to be an issue or not. And so that's the best advice I could give on that, is without you having to go to law school yourself and figure out these rules, which the Patent Office and the courts are still trying to figure out as far as what is this abstract idea standard and what qualifies as patentable subject matter, what doesn't. It's a very gray area right now, and the courts are still bouncing around as far as what is and what is not patentable subject matter, again, particularly in the software space. But as I said, I mean, that's just a conversation you should have with a patent attorney, and they can give you their opinion on what your chances might be with respect to that issue. So beyond that threshold issue, the other three standards that the patent examiners look at is first of all, usefulness, which that's kind of a throwaway standard because you can argue that anything is useful. So that typically there's no issue with that one. The second standard is what we call novelty, meaning that what you've invented is unique. No one else has come up with the same exact thing before. And that tends to be a pretty easy standard as well, as long as at least one aspect of what you've developed is unique. So that only becomes an issue if someone else has already invented the same exact thing as you. And so again, it's typically doesn't come up very often. The most common issue though, and the most difficult one sometimes to overcome, is this third standard of what we call non-obviousness. And this acronym here is to a person having ordinary skill in the art. And so basically what that means is that the examiner that gets assigned to your case, to your application, they will already have the relevant background. So like if you've developed something that's software related, you will get an examiner that typically will have at least a bachelor's degree in computer science or maybe computer engineering. So they've got the requisite kind of foundational knowledge in that area. So you're not going to get an examiner that's got like a mechanical background looking at a pharmaceutical invention. They try to send these cases to appropriate examiners. And so when an examiner gets your application, they try to place themselves into the shoes of a person having ordinary skill in the art. So if your invention requires bachelor level knowledge on this technology, then they kind of place themselves in the shoes of a person having that amount of skill or knowledge or expertise in with respect to that type of technology. And so then what they do is they perform what's called a patent search. So they go out and they look for anything that's been published. Typically, they're going to focus on patent databases, so published patents and published applications, though they can also look at what's called non-patent literature. So let's just say there's a YouTube video or some e-commerce website that has a similar product, or just any publicly accessible publication that could be out there. And they pull together as much of that as they can, and they look to see whether any of that information comes close enough to either teach exactly what you've developed or come close enough to where it's not a significant departure from what's already out there. So in other words, taking everything that's come before your invention, whether patented or not, if your invention is simply just a quote unquote obvious combination of or an obvious improvement over what's already out there, then your application is going to be rejected as being obvious in light of that prior art. And kind of similar to the abstract idea issue, this non-obviousness standard is also a little bit of a gray area. And there's obviously some subjectivity there where you're dealing with this human examiner that's got their own opinions on what the prior art teaches. And so oftentimes there's going to be a little bit of back and forth between the applicant or the applicant's attorney and the examiner to try to work through these issues. But in other words, so I mean, as far as this non-obviousness standard, as long as you've got an improvement that's not just unique, but significantly unique, meaning not just the next step or logical step in the evolution of this particular type of product or technology, but really a significant departure where it would not have been obvious for someone to look at the problem that you've solved and immediately come up with your invention as a solution to that problem. As long as we can show that there was some additional features there that were not obvious, that is not kind of logical to do based on the teachings of the prior art, then we can typically overcome that obviousness or non-obviousness standard as well. And again, this is something where when a client comes to us, we'll try to give them our gut feeling on each of these issues as well, at least insofar as my or our experience in that particular technology area. And there's also kind of like the freedom to operate search that I mentioned before. There are also what's called patentability searches, where we can kind of do a further search in the prior art to see what's already out there, and then just have that much more information to make an informed decision one way or the other, whether it's something that's potentially worth pursuing or not. So it's just, again, a conversation to definitely have when you develop something new. And again, I mentioned this phrase already, but prior art, again, it's basically any third-party disclosure anywhere in the world that predates your application filing date, basically. So if, let's say, something comes out by a third party even the day before you file your application, that could be used as prior art in determining whether your invention is sufficiently unique enough to be deserving of a patent. And so because of that, oftentimes you'll hear that the sooner you file your application, the better, just because we're no longer on a first to invent system, we're on a first to file system. So it doesn't matter who invents something first, but only who files their application first. So it's a little bit of a race to the patent office, though I don't like to say that a lot because it's kind of, I don't know, it sounds like fear mongering in a sense, but I mean, that is the reality. So all I would say is that if you're in a more competitive field, as far as what your competitors are doing and how active the industry is as far as maybe working towards a solution to the same problem you're working on, then that would be a situation where certainly you'd want to file sooner rather than later. But if you're coming up with some brand new type of product or technology, then you might have a little more time to get that application filed. So all of this is going to be case by case, but just something to keep in mind is that prior art issue. Another important thing to keep in mind when it comes to patents is this idea of public disclosure. And so under the patent rules, a public disclosure is defined as any disclosure that's not covered by a non-disclosure agreement or an NDA or confidentiality agreement. It could also be any public use or public display, or even any public or private sale or offer for sale, or commercial exploitation of the invention anywhere in the world. So even things like, again, taking the commercial exploitation portion of that definition, that comes up oftentimes like in the software context, where when you're trying to get a patent on software, oftentimes what you're going to try to patent is the underlying algorithms. And those algorithms are defined as essentially a method or a process of doing something. So you're not protecting, let's say, I don't know, a financial software or something like that, but rather the underlying algorithm. So maybe you've come up with a new way of calculating some figure. And then so rather than claiming financial software, you'd be claiming a method of doing such and such, so comprising the steps of ABC. And so those underlying algorithms are what you're protecting in a patent application for software. And when you sell your software, those algorithms typically aren't going to be seen by the end user. They're oftentimes are going to be server side, or they're just part of the compiled software that the average consumer is not going to be able to figure out. However, because they're part of the software that's being sold, or in other words, being commercialized, that is still considered public disclosure under these patent rules. So if you are in the software business and you think you might have software or aspects of your software that's worth patenting, again, that's something you want to keep confidential. Don't take it to market yet until you figure out these patent options. Now, as you see here on the slide, you do have a 1-year grace period in the United States from the date of your first public disclosure to still file a patent application. So meaning if you happen to disclose to someone publicly or not covered by an NDA, or if you offer your invention for sale or actually sell it, that first date of public disclosure starts this 1-year clock. And as long as you file within that 1-year window, you're going to be okay. But if you wait longer than that 1 year, you're out of luck, basically. Essentially, your prior disclosure would count as prior art against you for any disclosures that are more than a year old. And that's only in the U.S. Outside the U.S., I say outside North America because Canada and Mexico kind of have similar rules, but they're not as lenient. But definitely outside of North America, there is no grace period. So in other words, if you publicly disclose before filing any patent applications, you're now essentially out of luck as far as getting any patents in Europe, China, or anywhere else outside of North America. So again, if you are a company that's really doing this or exploring your patent options to build value in your business so as to attract investors or maybe set your business up for acquisition, keeping at least keeping the options open. Maybe you're not going to file in other countries, but keeping the option open to file in other countries is going to make you more valuable than only being able to pursue a patent in the US. And again, if you keep that option open, then that's something that a licensee or a purchaser or even investors might get on board and then help you fund those international patents. And so all that's to say, then you want to keep your inventions confidential if possible until you're patent pending. And then once you're patent pending, as I said earlier, we can string these applications along, and they would all be given the same filing date as your U.S. application. So the rule of thumb is as long as you get your U.S. application filed before any public disclosure takes place, you're able to keep all these options open for roughly 12 to 30 months. Again, assuming that you're able to string everything along during the allotted time frame or timetables that are given for the foreign filings. So again, not to say you have to file in all these countries, but as long as you file your U.S. application first, you're keeping all these other options open. So if you do have to disclose to someone in the meantime, again, just use a non-disclosure agreement. And if someone signs that before you disclose the information, that disclosure is not considered public disclosure. So someone just asked, how hard is that 1 year period? Is it to the day, to the month? It is to the day. So if you, let's say, disclose something today, then you've got until, gosh, I don't even know what date it is with working all this lockdown stuff. So today's March 23rd. So March 23rd, 2021 would be the hard cutoff as far as your ability to file in the U.S. Now, with that said, it would typically come down to that coming up during litigation in most cases. So in other words, if you publicly disclose or if you happen to show it to someone or sell it to somebody and then you waited longer than a year, you could still file your application. You might even get a patent. But if it should ever come to light that there was a public disclosure more than 12 months before your filing date, a third party could use that to basically knock your patent out. They could invalidate it based on that public disclosure. But so it is basically down to the specific day. Looks like Matt also asked as far as how to string along to get to the 30 months. Again, that's something I can talk about on a case-by-case basis, not to muddy the waters too much, but I will say typically the timeline that most people follow is you file the U.S. application first. Within 12 months of your U.S. filing date, you file what's called a PCT application. That stands for Patent Cooperation Treaty. You guys can Google that if you want and look into it more, or I'm happy to have a further conversation with any of you on that topic. But if you do file that PCT application within that 12-month window, that's going to then hold your place in line internationally, to where then you can file in the countries of your choosing within the subsequent 18-month period. So Europe, Japan, China, basically most of the industrialized world, it's like roughly like 127 or 130 countries that are signatories to the PCT process. And so by filing within that subsequent roughly 18-month window after filing the PCT application, let's say you file an application in Japan, that Japanese application would be backdated and given the same filing date as your US application. So when you look at the total timeline, again, you file in the US first, and then you have 12 months to file the PCT, and then roughly another 18, 19 months beyond the PCT application to file in those foreign countries of your choosing. You get roughly a total of 30 to 31 months measured from your US filing date to make those decisions. And again, I mean, it's all going to be case by case, but that tends to be the typical path that people will take. So again, it's easier to kind of talk to people on a case-by-case basis, so to figure out what's the best strategy for your particular situation. But that's how you string them along to get that full 30 to 31 months. So real quick, we won't spend a ton of time on this, but there's three types of patents. There's what we call utility patents, there's design patents, and then there's a third called plant patents. I don't handle plant patents just because I've never had a client that ever needed one. It's really limited to if you're producing or developing asexually reproducing plants that are sufficiently unique. You could get a plant patent. So like an example would be like the Monsanto soybean would be like a plant patent. But most of my clients, or I should say all of my clients, and I would say generally for most industries, what companies and what people focus on are the utility patents and the design patents. And there's similar types of patents in other countries as well. So utility patents, these are typically going to be the strongest or at least the broadest type of patents out there. Essentially what they do is they protect the structural or functional features of an invention, or in other words, the way an invention works. So as the name implies, we're protecting the utilitarian aspects of an invention with utility patents. The term of a utility patent is 20 years from the earliest filing date. So, I mean, the rule of thumb is about 20 years. In reality, you end up getting about 17 years because it typically takes about 3 years on average for a patent application to go through the process, but there's ways to speed that up as well. So again, I won't go off into the weeds on that one, but just remember 20 years. And with a utility patent, what you see is, and this is the case for any utility patent if you want to go on Google Patents and look one up, but they basically describe the invention in words, and typically the structural details of an invention, though again with methods and stuff, you're reciting the steps in a process rather than any kind of structural details. But this is an example here of a mechanical device, if you will. Specifically, it's a batting weight that you can see kind of sits at the mid-weight point of a bat, or the center of mass, essentially, of a bat, rather than the traditional batting weights that are kind of donut shaped and sit at the very end of a bat. And so this particular client came up with this design because with the traditional ones sitting at the end, it adds weight to the bat, but it also throws off the weight distribution. And so it kind of gives you an unnatural throw when you're taking those practice swings. So with his sitting right at the center of mass, it adds weight to the bat without throwing off the weight distribution. And you could also, just given the low profile of this device, you could take live swings with it without worrying about the ball coming into contact and then going off in some wild trajectory. It's going to basically go where you hit it for the most part. And so what you see at the end of every utility patent, in every utility patent, there's going to be like an abstract and what we call a specification, kind of describes all the various features and embodiments, etc. You'll have a set of drawings typically that will illustrate what the invention looks like in at least one embodiment. But then the most critical part of a patent is at the very end of the document, and it's these numbered paragraphs. And it always starts with what is claimed, or something to that effect. I claim, sometimes it'll say, or we claim. But then you'll get these numbered paragraphs, and each one of these is what we call a claim. And there's what we call independent claims, basically claims that kind of stand on their own. And then there's dependent claims, like this claim 2, where it kind of hangs off of another claim. So you see this one says the batting skills development device of claim 1. So it's basically building on what's claimed or what's recited in this first claim. But the way these claims work is, I mean, this is what a court looks at when determining the issue of infringement. So in order for a product to infringe a utility patent, a product or service, that we'll just say product for simplicity purposes, but that product basically has to incorporate every single recited element of at least one of these claims. So in other words, let's say this independent claim has elements A, B, and C. If this alleged infringing product only has A and B, or A and C, or in other words, not all of the elements recited, then that product would be considered non-infringing. So in order for that product to be infringing, it has to have every recited element of at least one of these independent claims. So because of that, it's always key to make these claims as broad as possible, because the more limitations you have in the claims, the easier it is for somebody to work around potentially, because all they have to do is just leave out one of those limitations and they'd be able to get around that claim. So typically then what we're including in these is just the most critical elements. In other words, the elements that have to be in the product in order for the product to function as intended. And anything that would be optional, we put those into dependent claims, or we just leave them out of the claims completely. That way, if a competitor wants to make a competing product, their product would have to include all of these recited elements. I mean, that's the ultimate goal when writing these claims. Now, sometimes, depending on what prior art is already out there, you might not be able to get a claim that broad. Sometimes you'd have to include additional limitations in order to distinguish over any prior art that the examiner might turn up. But then the thought process in that scenario is that you've still created a better version of the product, such that even getting a slightly narrower patent is oftentimes still going to be valuable for you, because you're going to be able to stop competitors from making your improved version of that product or your better version of that product. But I just mention all this because these claims are very critical, and some of you might and may already have, it sounds like, filed your own provisional applications. And I didn't get into the differences between provisional and non-provisional, again, just for the sake of time. Ultimately, in order to get a patent, you have to file a non-provisional application. But you can file as a first step what we call a provisional, just kind of hold your place in line for up to 12 months. Within that 12-month period, you've got to then file the non-provisional. Again, it's all case by case, even there, as far as whether it would make sense to just jump right into a non-provisional or start with a provisional, et cetera. So I'm happy to have that conversation on a one-on-one basis. But all it's to say is that a provisional does not have to include claims. And that's why you guys are often able to file your own provisionals. But when it comes time to take the non-provisional step, it really is critical to have a patent attorney or a patent agent help you with that process, just because every single word in these claims matter. Sometimes even the A's, as far as like singular versus plural, sometimes I've seen that make a difference as far as whether a third-party product is infringing or not. And so every word in these claims matters. And they will be scrutinized if you ever get into a lawsuit over someone that's alleged infringing your patent. So it's really important to have someone assist you with drafting these claims, but because that is the key portion of utility patents. So design patents. Utility protects the way an invention functions. Design patents protect basically the way an invention looks. So and this typically is going to come up more so with respect to hard goods. Sometimes it could be used with software, though. If you have a graphical user interface that has a unique look to it, you could use design patents to protect those GUIs. But it really is just protecting a look rather than the underlying functionality. Oops. And so utility patents have a 20-year term. Design patents have a 15-year term. It kind of varies from country to country. Some countries will give you up to 25 years, but most will give you about 15. So with utility patents, again, you have those claims. You have this lengthy, sometimes written description about the various features of what you've invented. With design patents, you literally just have a series of drawings. And typically it's going to be a perspective view most often, but also a top view, bottom view, left, right side views, and front and back views, just showing your product from every angle essentially. And sometimes you'll also have these types of additional figures that kind of show the product in use just for context. But there is no written description beyond that. You'll see that there's kind of a little description of what each drawing is showing you, but this is the written description here. It's just a description of the drawings, what it shows. So the way that infringement works with design patents is there's no what we call all elements rule like with utility patents. Instead, a judge or jury would essentially take the third party product that you've alleged is infringing your patent, and they will compare that against the drawings of your design patent. And if the drawings, or I should say, if the third party product looks substantially similar to the design patent drawings, then the court would find the product to be infringing. So substantial similarity is obviously another kind of gray area standard. Obviously, the more similar a product looks to the drawings, the stronger your claim is going to be. But it just comes down to how similar the product looks to the drawings, and it's a little more complicated than that as well, because you're really looking at the non-functional features or the non-functional aspects of the drawings. But it's going to provide you with typically narrower protection than a utility patent. So I say that, like, for example, with this one, this shows a product that has essentially a product that's circular in cross section. If someone were to make one that, let's say, is hexagonal or triangular in cross section, maybe they make it a little longer even and change the dimensions, change the overall look. Those changes could be enough in the aggregate to get around this design patent. Obviously, it wouldn't function as nicely or as well as this particular version for the reasons I mentioned before, but it could be a workaround to this design patent. Whereas if you had a utility patent on this product, you could potentially go broader than this specific version. So for example, if you were able to get away with just saying a weighted or a batting weight that's configured for sitting at the center of mass of the bat, if you're able to get a claim that broad, you see I didn't mention the shape at all. And so that type of utility patent claim could cover this version or a triangular version or hexagonal, etc. And so your coverage would be broader in that particular scenario. So it ultimately just depends on how broad you can go in a utility patent, but typically words could have different interpretations, and so there's wiggle room there. There's room to argue as far as whether a third party's product infringes those claims. Whereas with the design patent, you're not, I wouldn't say stuck, but you're set in what the scope of your rights actually cover based on what's actually shown in the drawing. So there's less up for debate with a design patent. But with that said, there still is a lot of benefit with design patents. Again, particularly if you have a hard good. For one, design patents tend to be cheaper to obtain, relatively speaking. They're also typically quicker to obtain. You can oftentimes get a design patent through within about 12 months to maybe 18 at the max, but on the average, it's been about 12 months lately. And so you're able to get that design patent fairly quickly. And it is possible, if the facts warrant it, you could pursue both utility and design patents on the same product. As you see here with this batting weight, this client pursued both. And so that could be beneficial as well, where you get both filed, you get a design patent relatively quickly so that you have some amount of protection for when that first generation of knockoffs would inevitably come onto the scene. And I say inevitably, I mean, obviously it depends on how popular the product is and everything else, but if you've ever considered Kickstarter as a way to get funding, there are companies out there that their business essentially entails just watching what's trending most or best on Kickstarter, what's making the most money, and those are the products they pick to knock off. and if you don't have a patent application, or I should say a patent issued yet, you really have no recourse against those knockoffs unless and until you get a patent in hand. So if you're able to get a design patent in relatively short order, that tends to be useful, just because the first generation of knockoffs tends to be identical to your product, because competitors that are in that business aren't going to usually waste a lot of time trying to redesign what you've created. Instead, they're just going to take one of yours, they're going to send it to somebody in China or overseas and say, make this. And so because those knockoffs would likely be identical, if you had a design patent, albeit narrower than a utility, it could still stop those identical knockoffs or those substantially similar knockoffs. Meanwhile, your utility patent application might still be pending, and you could ultimately end up with broader or stronger rights on your invention once that utility patent is granted, to then stop people that try to get creative on their workarounds. But for the identical knockoffs and the confusingly or substantially similar knockoffs, a design patent could prove quite useful. So moving on to trademarks. Again, the patents is kind of the most complex. That's kind of takes the longest to get through. Trademarks is not as long, but certainly, again, if you have any questions as I'm going through this, let me know. And then I'm always happy to have one-on-one conversations at your convenience to talk about your particular intellectual property. So as I mentioned before, trademarks are basically any non-functional and unique source identifiers that are used in connection with providing goods or services. So in other words, when you take something to market, whatever source identifiers you're using on those products or services to help consumers associate you with the company behind those goods and services, those are all trademarks. So the common ones would be like brand names or company names, logos like the Nike swoosh, taglines like just do it. It could also be things like jingles. So the NBC chimes is protectable as a trademark. Product packaging or product shape. So the classic Coca-Cola bottle shape, that's protectable as a trademark and is protected as a trademark. Product color. The example I always give is there's an insulation company called Owens Corning, and they sell insulation that's the color pink, and they have what's called trade dress rights. It's a form of trademark protection on that pink color, so no one else can make pink colored insulation. Even its store appearance or store decor is potentially protectable. So the Apple store, their kind of minimalistic layout and everything, that the look and feel of their store is protected as trade dress as well. So again, it literally could be anything that a consumer would use to associate or that you would use to help consumers associate you as the company or entity behind those goods and services. And those listed, though, tend to be the most common ones. So essentially, obviously, trademark rights give you the ability to stop your competitors from using the same or similar marks. But it really is a consumer protection type of law, where these trademark rules are in place to prevent what we call consumer confusion. These rules don't want a scenario to come up where, let's say someone's selling shoes and they call them Nike, but they spell it with 2 E's instead of 1, and those end up on the store shelf right next to the real Nikes. A consumer might buy the knockoffs thinking that they're the real ones because the names look so similar, and then take them home and they could fall apart. And now they think that Nike is selling low quality products. And so it just creates all this consumer confusion by having similar brands in the same space. And so these trademark laws are intended to prevent those types of scenarios. As I just said, though, it is really giving you protection in the same space. And so these trademark rules give you the exclusive right to prevent competitors from adopting what would be considered a confusingly similar mark in connection with similar or competing goods or services. So if someone is in a completely different space than you, that could be a non-infringing type scenario. So an example would be with the mark Delta, where you have Delta Airlines, Delta Dental, and Delta Faucet. It's all the same mark, but they're able to coexist. There's no likelihood of confusion there, because no consumer is going to reasonably believe that the same company is behind an airline service, dental services, and faucets. Another example that I always give is the mark Dove, where there's Dove soap and Dove chocolate. Again, the same mark, but the underlying goods are so different that no consumer is going to think it's the same company. So I mention that because as you come up with your own product names or taglines, etc., oftentimes one of the first steps you'll take is just doing like a quick Google search or internet search to see if anyone else is using that name or tagline or what have you. If you do find someone that's using the same name or a similar name, you also have to look at what are they doing under that name or in connection with that mark. Because if they're in a completely different space than you, you're potentially going to be okay to use that mark as well. And again, that's a conversation I'm always happy to have with clients, or even prospective clients, is figuring out whether they're free and clear to use a mark and potentially register it as well. The other thing to keep in mind too is, as I said with my Nike example, simply adding a letter or changing a letter or spelling something differently or making it one word instead of two, those types of minor changes typically aren't going to be significant enough. And I say that because if you do come up with a name and you find somebody else that's using that same name in your space, you're probably not going to be able to use just a different spelling of that word, or something like that, or make it singular instead of plural, or vice versa. It's all case by case still, but that tends to be a pretty general rule of thumb when it comes to trademarks. Is you want to make sure it's significantly or substantially unique enough compared to other marks in that space, and not just for the ability to get a registration on your mark, or to avoid infringement, but really to set yourself apart from your competitors as well. I mean, that's ultimately, I think, more important, or the most important thing when it comes to trademarks, is making your mark unique enough to where consumers are going to be able to find you and not one of your competitors. So you might be able to get away, maybe a field of marks is so crowded that a term is almost generic that you've come up with, and you want to still use that and maybe add an S to the end or something like that. And you might be able to do that, but then if consumers or prospective customers are trying to find you online, if they're doing an internet search and they search for your name, then in that scenario, your competitors would probably pop up as results as well. And so you might lose some prospective customers by not having a unique enough name. So just all things to consider as you're coming up with a trademark for your company or for a product name, etc. Similar to patents, trademark rights are country specific. So if you want to have rights in Europe or China or elsewhere, you've got to file applications in those countries. Now, the US is a little bit of a unique animal. There are other countries that kind of have a similar scheme, but not many. But the US, there is what we call common law trademark rights, which I'll get to in a minute. But there's three types of trademark rights in the US. The two most common are common law and federal. I won't talk too much about state trademarks because they just aren't very applicable these days. If you're doing business in only one state, then a state trademark would be what you consider. But otherwise, if you're doing any business across state lines, you're going to want to go for the federal trademark, and skip over the state. So it's just, in this day and age, it's not really utilized that often. I think in the 14 years I've been doing this, I've only filed definitely less than 5. I think 3 or 4 state trademark applications. Just no one has a need for them anymore. So common law rights, anytime you see a TM or an SM next to any kind of brand name, that's an assertion of common law trademark rights. Basically, these are rights that arise automatically just by virtue of you using a mark. There's no application process, no costs involved. You don't have to file anything. It's just on day one, when you launch your business or when you launch a product or service, you're legally allowed to use a TM or an SM. So more often than not, you see TM, that's short for trademark. If you're in a business that's only providing services, you might choose to use SM, which stands for service mark. But even with service providers, they typically will use the TM as well, just because that's more commonly recognized. So there's no right or wrong way to do it. If you're not sure, just use a TM or ask me or someone else. But it's not even required to actually mark. But again, it's highly encouraged just to put people on notice that you're asserting that as your trademark. So the catch though with common law trademark rights, as you'll see here, is that these rights are geographically limited in scope. So in other words, if you launch your business and you're based in Orange County and you've only made sales to people in Orange County, then that's essentially where your common law rights are going to reside. So if someone else in Northern California or in another state or geographic region starts to use even the same exact mark as you in connection with the same exact goods or services, your common law rights in that scenario would likely not be broad enough to stop them from copying your name or from using your name as well. And even with the geographic limitations, if you make, let's say, just one sale in Orange County, those rights aren't going to be as strong as if you've made 1,000 sales in Orange County. So when you assert common law trademark rights against someone, the courts are going to be looking at not just where you've made sales, but how many sales you've made in order to determine whether you even have strong enough rights that could be asserted against somebody else. So yes, these rights are free of charge, and you're encouraged to use a TM when you start to use a new mark. But they're not the strongest and they're not the easiest to enforce. So because of that, typically what people go for is, again, either a state or a federal registration. So again, if you're only operating in one state, so for example, California, you can file an application with the Secretary of State, and once you obtain your registration, you would then have statewide rights. So even if you're only in Orange County, you've only made sales in Orange County, you could get a state trademark registration, and now you have protection throughout the entire state of California. So that if someone comes along after you in Northern California, let's say, for example, and uses the same or similar mark, your state trademark rights would be strong enough to stop them from doing that. So with the state trademark application, just like with the federal, we'll talk about in a second here, there is a formal application process and fees that would have to be paid to pursue that. So the common law is the only one that's free of charge. And so federal is like I said, typically the one people go for, at least eventually. Maybe when they first launch, they might just use the TM for a while until they have the budget to pursue the federal, or until they're starting to do business across state lines. But once you pursue and obtain that federal trademark registration, instead of using a TM, you then use this little R in a circle symbol. So anytime you see that symbol, that's basically an assertion of federal trademark rights. Again, not required to mark with that symbol, but it's highly encouraged because you're putting people on notice that this is a federal trademark, and it gives you potential to recover additional money damages if you were to sue somebody down the road for federal trademark infringement. So the only requirement in order to get a federal trademark registration is that you've got to be doing business across state lines. So if you're in the goods or services business, and those services are able to be provided to people in other states, then that's one way to provide these services, whether you're shipping goods to people in other states or providing services to people in other states. That would be considered using the mark in interstate commerce. The other option is, let's say you've just got a brick and mortar in California. Let's say it's like a hotel or a restaurant. If you have people travel from other states and visit your brick and mortar establishment, that is also considered using the mark in interstate commerce. It's basically just money has to cross state lines in one way or another. And once that happens, you're eligible to obtain a federal trademark registration on your trademark. Again, not to get into too far off into the weeds, but there are also ways to file before you actually start doing business across state lines. You could file based on what's called intended use in order to lock that name in as early as possible. So if you plan on starting those interstate sales within the next, say, 1 to 3 years, then you can apply for your federal trademark registration based on intended use to kind of get the process going. And then that basically, if you go that route, the trademark office would examine it, your application. If it passes examination, it would be allowed, but then the trademark office essentially holds on to your registration certificate until you make those out-of-state sales, and then let the trademark office know that, okay, I'm now using the mark in interstate commerce, and then they would release the certificate to you, essentially, is kind of how it works. So you don't actually have to be doing business across state lines in order to begin the process to obtain those rights. It's just in order to complete the process, you gotta make those out-of-state sales or shipments. As far as the term on these trademarks, the actual registrations, they have to, you've got these renewals that have to be paid every so often. So the first one is like at the 6th anniversary, and then after that it's just every 10th anniversary. And they're only a few $100s, and so it's not expensive to maintain. But they could last for as long as the trademark's actually used, and so that's why you've got these companies that have been around for decades. And they've continued to maintain their trademark rights because those marks are actually being used. But the rule with trademarks is basically use it or lose it. So if you stop using a mark and that non-use continues for a period of 3 years or more, it's going to be presumed that you've abandoned those trademark rights. So it's just, yeah, a matter of continuing to use it, whether it's you that continues to use it, or if you sell the business to someone else or license the trademark rights to someone else, whoever your successors are, as long as they continue to use the mark, then these rights could go on in perpetuity. Whereas, again, with patents, you've got this limited monopoly of 15 or 20 years, and then once those patents expire, you no longer have enforceable rights. With the trademark stuff, you do in perpetuity. So copyrights, again, it's basically just protects creative expressions. And again, it's not the ideas themselves, but the expressions of the ideas. And this can be a difficult concept to grasp sometimes, but the example I like to give is like with a recipe book. The recipe book might contain a bunch of different recipes, but if you have a copyright on the recipe book itself, what you have is basically the right to prevent anyone else from making unauthorized copies of that recipe book. What a copyright does not get you in that scenario is the ability to prevent anyone from following those recipes or using those recipes to make whatever the recipes are intended to make. It's protecting that creative expression of the book itself and preventing unauthorized reproduction of the book, but it's not protecting the underlying concepts that are conveyed in the book. And so oftentimes that's not even an issue that comes up with copyright. I think a lot of people appreciate and understand that usually you're going to use copyright to protect things like, again, photos, songs, any kind of written works, whether it's like a literary work or instruction manuals, things like that, workbooks that you might use for educational purposes. All those things would be protected through copyright. And if there are any kind of underlying concepts within those works that are potentially patentable, then you could also look at patenting those concepts to get some additional layers of protection there. So it's kind of similar with copyrights as with patents. You got this right to prevent others from essentially making or using, in the copyright world, we say reproducing or distributing or performing the work. So if it's music in particular, let's say, or a movie, motion picture, you can't perform the work in public without the copyright owner's permission. But again, it's all the creative expressions is what copyright protects. So anytime you see the little C in a circle symbol, that's an expression of, or an assertion of copyright protection. So you'll see, like down here in the slide deck, we've got the little copyright notice, and that's kind of the general language that you'll typically see on these things. But not required, but highly encouraged. But yeah, didn't sound like a lot of people were that interested in copyright. Certainly, though, if anyone has any questions, I can go into more detail on anything that's on this slide. But again, creative expressions is the takeaway with copyrights. We won't worry about the term. The term has been changed throughout the years. So, I mean, generally speaking, it's about 70 years from the last surviving author's death. So it's a lot longer for copyright, but the scope of protection tends to be narrower because, again, you're just protecting a specific creative expression rather than any of the underlying ideas that are conveyed in that expression. So with copyrights, there is no application process or cost to acquire the rights, technically speaking. I mean, the rule is that the second that you create something, once you put a creative expression into what we call a tangible medium, like putting pen to paper or taking a picture, you automatically have these rights. But the catch is that in order to enforce those rights, you have to go through the registration process. So in other words, before you can sue someone for copyright infringement, you have to go through this registration process, filing a copyright application with the US Copyright Office. It's beneficial to do that in a timely manner. So in other words, either before you go public with the work or within 3 months from when you go public with the work. By doing that, you can potentially recover what we call statutory damages, or essentially this automatic damage amount that the court would award you. And that could range anywhere from, I believe it's like $150 to $130,000 per work infringed. So obviously it's a big scale there, a wide spectrum. So I mean, where you would fall on that just depends on how egregious the infringement is in your particular case. As far as the alleged infringer, how many copies did they distribute, whether it was willful or not, et cetera, as far as how much in statutory damage you might be able to get. But the alternative, if you don't timely register the work, you could still sue someone for copyright infringement after you go through that registration process. But then what you'd be able to get out of that is what we call an injunction. So meaning you could stop the infringer from continuing to infringe the work. And you can also get what we call actual damages, or the actual dollar amount by which you've been damaged, which in most cases is going to be a lot less than the statutory damages. So for example, if you're selling a song for 99 cents and someone makes one unauthorized copy, your actual damages would be about $1. Whereas with statutory damages, you could get hundreds or thousands of dollars just for that one song being that one unauthorized copy. So having that timely registering the work and being able to recover statutory damages from someone essentially gives your rights some teeth. So when you send a cease and desist letter, you can let them know that you timely registered the work. You can recover statutory damages from them, and that's going to be typically enough leverage to get them to actually comply with your demands, as compared to if you don't timely register the work. And if they're sophisticated enough to figure out that you didn't timely register, they're probably not going to listen to you as far as stopping what they're doing. So there's definitely some benefit there. But all I would say is that, I mean, depending on what your business is, you might have a lot of works that could be protected through copyright. Like if you have a website, if you have a bunch of like literature on your products or services, as to whether it would make sense to spend the money to register all those things, that really just depends on how important the content is to you, and the likelihood you think it might be taken and used by someone else, as far as which of those you might actually go through the registration process with. But I will say that filing copyright applications is the most straightforward application process as far as compared to like trademarks and patents and everything else. So a lot of my clients, I might do the first application for them, but if they have a lot of other works to register, they can usually use that first application as a template and then just do the rest themselves. And then you're just looking at like $55 in filing fees per application. So it's relatively inexpensive kind of in the grand scheme of things. And so you might have certain works that you think are worth going through that process for, to have those rights should you have to enforce them against somebody. So unlike patents and trademarks, copyrights do essentially extend automatically to most countries around the world. There's what's called the Berne Convention. And so all that means essentially, as far as what you need to know, is that as a US citizen or a resident of the US, if you create something in the US that's protectable through copyright, that's going to be recognized in all other Berne countries, which again is most of the industrialized world, without having to go through any formal application process in each of those countries. They still recommend that you go through the US registration process with the US Copyright Office, just so there's some documentation to evidence that you are the owner of this copyright, but you don't have to go through separate applications in other countries. So if you do find someone that's infringing your copyright in another country. You still have to obviously hire a law firm in that country to help you enforce those rights, but you don't have to go through any additional application process. So trade secrets, even simpler than the others, even simpler than copyrights. It's really just any information that you keep confidential within your business that has some value to your business by virtue of not being known to others. And so as long as you're taking reasonable measures under the circumstances to maintain that confidentiality, you're going to be able to maintain those trade secret rights. So a common example would be the Coca-Cola recipe. That's a trade secret I think everyone knows about. Obviously, only a handful of people actually know the recipe, know the trade secret, but that's because they've been taking reasonable measures under the circumstances to maintain that secrecy. So examples would be just giving access on a need-to-know basis, not letting everyone in your company access the information, having things password protected, having everyone in your company or anyone that needs access to the information to sign a confidentiality agreement. It's just what's reasonable under the circumstances for your particular situation. It's a limited right that you get, though. It's not as strong of a right like as, say, patents would be, and that's oftentimes what people decide between is, should I protect this through patents or through trade secret protection? Really with trade secret protection, what you get is a right to take action against anybody that illegally obtains the information or steals the information from you. So oftentimes this is going to be an employee within your company that leaks information or that quits and takes information with them and gives it to your competitor or spins off a competing company using that information. And so you could go after them for that misappropriation. So if someone were to hypothetically legally acquire the information, let's say someone buys your product, like let's say we're talking software, let's say they buy your software and they're able to decompile it and look at the source code and reverse engineer it, that is lawful to do. You would not have an action against them. Or if somebody just independently creates the same thing without knowledge of your trade secrets, that is also not actionable. So it's a limited cause of action you have, and again, it's really just limited to this stealing of the information and having a cause of action against those people that were involved in that illegal or that misappropriation of the information. So there's no application process or cost to acquire these rights, but typically you are going to be spending some amount of money as far as setting up what you would call a trade secret protection program. So in other words, like paying an attorney to draft an employment agreement or a confidentiality agreement, or hiring an IT company to make sure you've got the right security measures in place on your system, as far as having firewalls and antivirus software, things like that. Putting locks on your doors, physical locks. So that's where the costs come up with trade secrets, but you're not actually filing an application with anybody to register those rights or anything. So the term of a trade secret, basically it'll last as long as the information remains secret. Again, the Coca-Cola recipe has been around for decades, and the trade secret rights will continue as long as that recipe remains confidential. However, once the information is no longer confidential, once the cat's out of the bag, so to speak, you no longer have trade secret rights. So it could last for as little as a day if you're not really good at keeping the secret, or it could last in perpetuity. And so that's something that you would want to weigh, deciding whether you want to protect something as a trade secret or through patents, because those rights are essentially mutually exclusive. Because again, with patent rights, you're being given this limited monopoly in exchange for publicly disclosing how to make and use the invention through that patent application that you're filing. Whereas with trade secrets, you have that protection by virtue of not disclosing to anybody the details of those secrets. So it's essentially one or the other. Now, with some things, you might be able to get patent protection on certain aspects of your product and trade secret rights for other aspects. Again, using software as an example, maybe you're able to hold back some of those more specific details that you could keep server side and confidential, and keep those aspects protected as trade secrets while you go for a patent on kind of the overarching software or the overarching functionality or just certain features of your software. So again, just something to keep in mind, something to discuss with an attorney before you go public with anything, just to figure out what's the best strategy in your particular case for your particular invention or product or service. I mentioned that sometimes trade secret rights and copyrights are also mutually exclusive. Again, this typically comes into play with software, where if you're registering software with the Copyright Office, you want to be careful to redact any portions of the algorithms or the source code that you want to protect as a trade secret. And if you do that, then any of the redacted stuff can remain a trade secret because it won't be publicly disclosed through that copyright application. And again, something that I could advise you of further if any of you have specific questions on that issue. So just real quick, IP ownership. Actually, let's see. Yeah, there's a question here I see. Let's see. Yeah, from Philip. I'll answer that question at the end here. So IP ownership, I say absent a written agreement to the contrary, because any ownership agreements can be made however you guys want. If whoever you want to own your IP, you put it in writing, and that's going to be what controls that written document. But this is saying if there is no written agreement, which is not an ideal situation. You always want to have these things in writing, but absent a written agreement, these are the rules, the default rules, if you will. And I'll just focus mainly on the patent one, because that I think is the most important one. With patents, if there is no written agreement, let's say you and a friend or just another co-inventor co-develop something that ultimately gets patented, each co-inventor has an equal undivided ownership interest, and there's no profit sharing obligations to any co-inventors. So what that means then is, let's say you and a friend invent something, you get a patent on it, maybe you start a business, but you still own the patent personally. You and your friend could have a falling out, and your friend can go off, or your ex-friend at that point, start their own company using the same exact technology, and directly compete with you. And you would have no recourse in that scenario, because again, each inventor has an equal undivided ownership interest if there's no written agreement to the contrary. And they don't have to share profits with you either. So if you are developing something with somebody else, or just more than one person, the advisable way to go sooner rather than later is to start some kind of business entity, whether it's an LLC or a corporation, and then have what's called an assignment, where each of you effectively transfers your ownership interest over to the business entity. So it's the business entity that owns the IP rather than you personally. That way, if you do have a falling out with any of your partners, they could leave. You probably have to buy them out or whatever the terms of your operating agreement say, but they would not be able to take the IP with them. It stays in the business where you would be, and you can continue doing what you're doing and not have to worry about your ex-partner starting up a competing business. So sooner rather than later, again, it's always good to have the IP transferred to some kind of business entity to hold everything, to hold that ownership, so that you don't have to worry about these falling out situations. And I won't spend time on the other ones just in the interest of time, but again, if you have any questions about the other ones, I'm happy to answer them. So another thing to remember is, just because you pay to have something created does not automatically mean that you own that creation. And obviously this comes up in the context of employees or independent contractors. If you're paying somebody to create something for you, the fact that you're paying them by itself doesn't always mean that you now automatically own whatever they create for you. It varies from state to state, sometimes court to court, but sometimes there have been cases where court, when there is no written agreement that says the employee or the independent contractor assigns their ownership interest over to you, the employer, If there is no such written agreement, then the employee or the independent contractor could maintain ownership of that creation. And what you would have is the employer is what's called shop rights, or basically a license to use and commercialize that creation. But the creator, the employer, the independent contractor could also commercialize that creation separately, whether they license it or sell it to somebody else. So again, not always the case. Sometimes courts will say, well, especially if it's an employer-employee relationship, that what they create during the course of their employment is going to be owned by the employer, but that's not a guarantee. And so because it's not a guarantee, it's always advisable to have these agreements in writing. And so again, it's usually just a short little portion of an employment agreement or an independent contractor agreement that basically just says that anything that they create in the course of their employment will belong to you, the employer. They agree to assign all right, title, and interest over to you as the employer. So again, whether it's independent contractor or an employer-employee relationship, you want to have that language. And some of you may have heard the phrase work made for hire, and you might try to use that, but it's advisable not to. For one, it only applies to very limited types of copyrightable works. And they're very obscure types, like maps and things like that. So like, for example, if you were to hire someone to, like a software developer to help you code your software, that is not a work made for hire arrangement if it's an independent contractor situation, because software is not one of these limited types of copyrightable works, such that if you were to use that phrasing that this is a work made for hire situation, a court would not recognize that, and that could be a case where the independent contractor is able to maintain ownership of whatever they create. So typically what you want to have instead is again, what we call an assignment, where it just says, I assign all right, title, and interest over to you, the employer, for anything I create during the course of my employment with you. And that's going to avoid these issues here. Another thing with work made for hire arrangements, at least in California, if you use that phrasing, it actually turns that independent contractor into an employee, at least for insurance and tax purposes. So just another reason not to use that phrase. And again, it only applies to limited copyrightable work, so it doesn't work for patents, anything that would be patent related. If you want to make sure you own whatever someone creates for patent purposes, you want to have this assignment language in your agreements. And make sure to have these agreements before you actually jump into a relationship with somebody, meaning before the work is actually started, just to make sure that these arrangements are going to be enforceable for anything that employee or independent contractor creates during that relationship. So get these arrangements in writing and preferably reviewed by an attorney at the outset of any relationship. So just real quick on this slide, this just shows examples. And again, I'll give this slide deck to Philip and he can distribute it to everyone. So you'll have this slide deck to look back at later. And you can always, like I said, follow up with any questions with me directly. But these are just the four main types or four main ways that people can commercialize or monetize their IP. So take it to market yourself, license to someone else so that they could take to market and pay you some kind of royalty in exchange, sell the technology or the IP outright to somebody else, or some companies that, if you've ever heard the phrase patent troll or non-practicing entity, that's basically a company that holds a bunch of IP, particularly patents, and doesn't actually commercialize anything themselves, but they just go around and sue people who are using that technology without their permission. So again, as I said earlier, a patent gives you the right to exclude or prevent others. And so that's essentially the right that's being used in these types of patent troll situations, where they're just basically enforcing their rights and making money by collecting damage awards or settlement amounts from the accused infringers. So with all that kind of as a background, these 5 common startup mistakes will hopefully make more sense and won't require as much explaining. So number one, one of the most common mistakes I see is not having proper and documented chain of title. So again, this comes up with with respect to when you have a business that's got employees or independent contractors. You want to make sure you have all those written agreements in place, both ownership and confidentiality with any employees and contractors and partners. Particularly, again, if you're a startup that's going to be looking for funding, this is going to be one of the first questions that an investor is going to ask you during their due diligence is whether you've got proper chain of title with respect to all of your IP. And if you don't, then you're going to have to waste time scrambling to get those things. And hopefully you're still in contact with all of those employees and they're willing to sign these things. So it could just be a huge headache if you don't have this all lined up before you start talking to potential investors. Another thing that it's good to see when possible is you want to try to make sure that any employees or contractors or partners that you have don't have any obligations to prior employers. So this could even be you if you go start your own business. If you're leaving an employer that's kind of basically in the same business that you're now starting, there could be issues there as far as if you're trying to, let's say you're working for somebody and you're kind of developing this business on your own time. You're not ready to launch yet, but you're developing some of this IP while you're still an employee of this other company. Depending on how broad their employment agreement is with you, depending on whatever you signed with them when you were hired on, that language could be broad enough to allow them to assert ownership over these things that you're creating for your business that you're working on. Not always, but again, just depends on the breadth of that language, that IP ownership language that could be in that agreement. And so it's just a good thing to look into to make sure that you're not going to start a business around IP that's not actually owned by you or not completely owned by you. So just do that due diligence before you launch or before you start looking for money. Another startup mistake is publicly disclosing or commercializing your products or services before filing a patent application or waiting too long to file. Again, waiting longer than that 12-month grace period, or filing before, or publicly disclosing before you file, and now preventing yourself from pursuing foreign patent protection. So again, make sure to at least file a U.S. provisional application first. And as I said before, it is something, provisional could be something that you do yourself to save money. If you do, though, just make sure, this kind of ties into this next startup mistake, make sure that provisional application has as much detail as possible in it. What I mean by that is talk about every aspect of your invention. If we're talking like a mechanical device, talk about all the different components, how they interact or connect with one another, what their purposes are, what materials could be used, what dimensions could this thing be, any alternate embodiments, like are there alternate components that could be substituted to achieve the same thing, or are there additional features that you might add at some point down the road? Just be as detailed as possible in that provisional, because if that provisional is lacking in detail, when it comes time to file that non-provisional application, you will not get the priority claim, meaning that the non-provisional won't be backdated and given the provisional filing date, which is the whole purpose of starting with the provisional, is to put your flag in the ground as far as the filing date. Instead, if that provisional is lacking in detail, your non-provisional is going to stand on its own filing date. So you're going to potentially lose a whole year's worth of priority, and that could be another year's worth of potential prior art now that's going to come into the universe of what the examiner could consider when examining your application. So again, it's okay to try to file your own provisional application as long as it's as detailed and as exhaustive as possible. Still, best case is to have a patent attorney assist in some capacity, even if not preparing the entire application, at least reviewing it and providing some feedback on what you could add to it before you file. But don't make it just like a short one-page document. It shouldn't be like a bullet point list. It should be, I mean, just plain English descriptions. Doesn't have to be anything super technical. Just make sure the details are in there. There's no format requirement as far as how the information needs to be presented. It just has to be in there in some form or fashion. And so that's key for provisional. But when it comes time to do the non-provisional, definitely don't try to do it yourself. As I mentioned before, the claims have to be carefully drafted. And if not, you're going to end up with a patent that's worth no more than the paper it's printed on, so to speak. And if those claims, you might be able to get claims allowed on your own, but they might end up being a lot narrower than you could have otherwise gotten had you had the proper assistance. And so obviously it does cost a little money to have an attorney assist you with that, but if you're looking to spend any money to protect your idea through patents, it's worth spending a little more to actually get some meaningful protection that's going to give your business value and give you that the whole reason why you're pursuing that patent is to have value, not just to put a plaque up on the wall. And so you want to make sure that you're actually getting a return on that investment. So yeah, make sure if you're going to do a provisional, keep it detailed as possible, and let an expert help you with the non-provisional step. Fourth common mistake is not properly clearing your trademarks before use. So taking something to market, using a mark before you actually check to see if anyone else is using the same mark or something similar. So again, when you're doing this search, don't just search for the exact same mark, but anything that could be potentially similar. So if you're thinking of using a word that has different spellings or that could have like non-traditional spellings, search for those as well to make sure that no one's using just a slightly differently spelled mark that's basically the same thing. And again, this is, I'm always happy to do those types of clearance searches as well. And I typically do those types of clearance searches at no cost. So don't try to take that task on completely yourself, but as a first step, definitely, I mean, do a Google search, see what you turn up, but make sure you're searching for more than just the exact mark you're hoping to use. Now, I mean, the upside is that if you do miss something and you get a cease and desist letter with trademarks, typically that first letter is just going to tell you to use a different name. They're not going to ask for any kind of money damages at that point, unless you ignore them, and then they will come back and they might then file a lawsuit, and then they're going to ask you for compensation. But usually the first letter is just kind of a shot across the bow. So you would have a little bit of forgiveness there in most cases, but you're still going to have to spend time and money rebranding and conditioning your consumers about your new name and stuff. So it's still a headache and it still costs money. So better to just properly clear those trademarks right at the outset. And kind of similar to that, at least on the patent side though, is going to market before determining whether you have freedom to operate. So again, this is another type of search that can be done. You could pay an attorney to do it, or you could do it yourself through using tools like Google Patents. So if you just go to, I think they changed the URL, so I think now it's patents.google.com. And it works just like their normal search engine, but it's only patent literature. So you could just plug in like just plain English words that could be used to describe aspects of your invention, and the results would be any published patents or applications that use those same terms. So you can kind of use that to hone in on anything that might come close to what you're doing. And if you find anything, then you can run those by an attorney, because again, just because something looks similar on its face doesn't necessarily mean that you would be infringing that patent, because you have to look at the claims, and it's not even that cut and dried. Sometimes you have to look at what we call the prosecution history and other things to really determine the true scope of what a patent covers. But again, at least you could potentially do the initial legwork yourself to save some money by doing that initial searching to see what you might be able to turn up on your own before looking to an attorney for help. So just, this is the last slide, just real quick, I'll just run through these. Each of these kind of covers a different aspect of IP, and so these are just questions that are good to keep in mind. You don't even necessarily have to have the answers to these questions. A lot of these are better answered by a patent attorney or a patent agent or a trademark attorney or just an IP attorney generally. But the key to this slide is just to have these questions in the back of your mind as you're developing things, just so that you're not missing something that could have been protected. Particularly again with patents, where you've got a certain timeline that you have to stick to, otherwise you're out of luck. So just keep these things in mind. So who owns the IP that I create or commission? So make sure there's no obligations to assign. Are there any co-owners? If so, make sure you've got a written agreement with them as far as who owns what, or assign everything over to a business entity. Make sure you've got confidentiality agreements in place. And then just think about, are any aspects of your idea protectable and worth protecting? And you see I note that in each of these, because you might have a lot of things that are potentially protectable, but it might not be worth the money to protect everything you've got. So oftentimes companies will just focus on what they think are the most important, or their hero products, if you will. And that's what they focus on. And maybe they've got some other commodity products they're selling as well, or just other kind of simpler products that might not even rise to the level of being patentable. And so just not worth spending the money or the time on trying to get patents on those things. But just as you're developing things, just ask yourself that question: is any of this worth protecting? And beyond that, just having a conversation with an attorney to figure out if it's even possible. Is it potentially patentable? And same thing with copyright, any tangible works, instruction manuals, books, songs, etc. Is any of that worth copywriting? Again, as you're developing these things, so that you still can make these decisions in a timely manner. And then again, towards the bottom of the list, before you go to market, do any aspects of my planned products or services infringe any third-party rights? Always a good question to ask before you go to market and potentially open yourself or your company up to liability. And then the last question is just always a good one to keep in mind: is how can I monetize my IP? Again, you might not have one single answer at this early stage, but at least figure out what you're open to. So maybe all you want to do is take this thing to market, or maybe all you want to do is just develop something and then license it or sell it to somebody else. But knowing which directions you might be willing to take the company will help you plan accordingly. For example, again, if you're a startup that's looking to get funding and maybe take the thing to market yourself, but you're also open to a license or acquisition arrangement, then you want to explore any possible patent options you might have, again, to build that value in your business so that you have something to sell or license down the road. And timely filing your US application and keeping your international options open, again, to increase that value. So just knowing what options you're open to will kind of help you make these decisions and figure out which path is going to be best for you, and you can then plan accordingly. So yeah, with that, just looking at, there's just a couple questions here. And again, if you have any questions after this, I'm always available by phone and email. And so you're always welcome to call me or email me, and we can chat by phone. I can meet you in person, whatever is most convenient for you. But I'm always happy to answer questions. But looking at the questions we have now, so on trademarks, if someone files an intent to use, but then a different person starts selling goods around the nation with the same mark first, who is entitled to the federal trademark? So first to file the intent to use application, or first to actually use? That's a good question. So if you file an application based on intended use, that locks you in. It's considered your constructive date of first use as of your application filing date. So if you file and then somebody subsequently starts using the same or confusingly similar mark, you would have superior rights based on your earlier application filing date. Obviously, you have to complete the registration process and everything before you can actually sue them for federal trademark infringement, but you have that cause of action, and you would be the senior user as long as you complete that process by virtue of filing your application before they started using their mark. Let's see, Francisco asked, where do I find the freedom to operate search? So again, I mean, it's a search that many attorneys can perform for you. If you wanted to try to do it yourself, I would say that the most user-friendly tool, again, is Google Patents. And again, it's patents.google.com. And or you can just go onto Google and search patents or Google Patents, and it'll show up. But that database, it's constantly growing. Currently, it's got the U.S. patent database. It has the PCT database, which anybody that files in more than one country, I would say 90% of the time they're going through the PCT process. So it's a very robust database. And then there's also the European Patent Office database, as well as some of Japan and China, at least where there's English translations of the abstracts, at least. I think that might be it for now, but I mean, that's going to provides you a pretty good idea as far as whether someone's got a patent. I mean, if someone has a patent on something, they're probably going to have a patent in at least the U.S., if not Europe as well, or one or the other, or they filed a PCT application. So just by searching Google Patents, you're going to get a pretty good idea about what's out there. Now, I mean, depending on what search terms you use and stuff, it might be hard to narrow down and figure out or find the most relevant. But like I said, you could try to do your own search as a starting point, and then you can talk to an attorney if you want a more thorough, like freedom to operate type search to make those determinations for you. Yeah, that looks like that's all the questions. Looks like Francisco's got another question Francisco, I can answer that offline for you. Yeah, does anyone else have any questions? Feel free to just take yourself off mute if you want to ask a question, if you don't want to type it. I'll give everyone a few seconds to chime in if they want.
Hey, Justin. Oh, hi. Hello, Justin.
Yeah.
Can you hear me?
Yeah, I can. Yes.
Hi. This is Carol Coyne. Let's see. So I have a question about, or two questions about trademarks.
Yeah.
So first question is, you mentioned that for federal, you have to do business across state lines. Is there a minimum number of states you need to do business with?
Oh, that's a very good question, and actually there's not. So technically speaking, all it takes is one legitimate sale or shipment to an out-of-state person, and then you're eligible to obtain that registration. Obviously, they want to see continued use of the mark in interstate commerce, like not just one sale and that's it for several months or if not longer. And I also say legitimate because you can't just sell or ship to like a friend or a family member. It's got to be like a legitimate customer. Otherwise, it's looked at as a token sale, and that doesn't count. But yeah, technically all it takes is one. So once you make that first sale or shipment to a legitimate out-of-state entity, then you're eligible. And it technically doesn't even require like a sale per se. Like, so, I mean, some businesses are in the business of giving goods or services away at no charge. Just depends on the business and everything. So technically, it just has to be your goods or services have to be marked properly and then go across state lines to someone else. Or again, like I said, someone else could come across state lines to you in California to get those goods or services, and that counts as well. It's just the business has to travel across state in some form or fashion.
Okay.
Yeah.
Thank you. And then second question, you also mentioned before you start selling across state lines, you can send in the intent to use. So do you have to, I heard from a friend that you might have to submit twice if you haven't sold across state lines, but I guess I'm confused because you mentioned it was kind of a continuation.
So you don't file twice. There is an extra step in the process. So regardless of whether you file based on actual or intended use, the initial steps are the same. So you file the same application. It's the same filing fees and everything. It goes through the same examination process. And then where it branches off is after examination, there's kind of this, what we call an opposition window, that gives people a chance to oppose if they think you shouldn't be entitled to the registration. But 99% of the time that comes and goes with no issue. So then after that opposition window is where it branches. So if the application is based on actual use, meaning if the mark is already being used in interstate commerce as of that date, then the trademark office will give you the registration certificate. If, on the other hand, your application is still based on intended use at that point, you get what's called a notice of allowance. And that basically starts a 6-month clock within which time you have to use the mark in interstate commerce. And once you do, the additional step then is what's called a statement of use. And that's at that point you're providing basically the dates of first use and some specimens or some evidence showing that the trademark office that you're actually using the mark in connection with the goods and services that are listed in the application. So it's an additional step, and there is a small little fee that's paid at that point as well. So you're technically not filing twice, but there is that additional submission in connection with your application before it'll actually issue as a federal registration. And I say that
Ah,
you've got 6 months, but you can actually request extensions of time in 6-month increments, and you can request up to 5 of those. So in reality, once you get the notice of allowance, you can push it back as far as like 3.5 years if you need more time to ramp up and start business across state lines. You got to pay for those extensions. So the cheapest way to go is to start using the mark as quickly as possible, but you have the luxury of pushing that back if need be. But again, regardless of which application you file, the initial costs are the same, the process is the same, and you get that filing date kind of reserved. So again, with intended use, it might take you 3.5 years to complete the process, but your registration is going to be dated back to that original filing date when you filed the application. So once you get that stake in the ground, you would have superior rights over anyone that would come along after you trying to use the same or a similar mark.
right. Okay, great. Thanks for the clarification.
Yeah, of course.
Hi, this is Hal Walbrink, and thank you, by the way, this has been very informative.
Yeah, it's my pleasure.
I have a question regarding using a trademark. I've trademarked my business name and the logo and a tagline, but have not registered it. Now, in order for me to make my claims to those pieces of intellectual property, do I have to, what would I do? Because I'm a consulting business.
Mm-hmm.
So I don't really sell goods, I sell services. So what proof do I need for cross state lines usage?
No, it's good question. So what the trademark office, all they ask for is the dates of first use, and they basically take your word for it as far as whether those dates are accurate. Obviously, you want to be accurate because you don't want to commit fraud on the trademark office and risk losing that registration. But in addition to the dates, they want just some evidence to show that you're actually using the mark in connection with those services. So depending on what kind of consulting work you provide, if you have like a website that talks about those services and has that trademark and the taglines and everything on that web page, then a screenshot capture of that web page would suffice as far as the specimen of use that the trademark office would want to see. That's all you need for the registration. But if someone were to challenge the validity of those dates, like let's say you were to sue somebody for trademark infringement, one of their responses or one of their defenses might be that that your trademark is not valid, and they could try to challenge the use dates and say that you weren't actually using the mark as of those dates. And so to counter that, you would want to have like invoices or like if your services entail like providing advice, maybe some of that advice is being provided via email, and maybe your trademarks are in the signature block of those emails. Those emails are going to be dated or time stamped, so that would be good evidence. I mean, just anything to help prove that you're actually using the mark in connection with those services as of those dates. So yeah, typically it's going to be like invoices and receipts and things like that that are going to be dated.
Okay.
They'll have the recipient's address on it to show that they're in another state. But none of that you provide to the trademark office. It's just you keep that in your own records just in case you have to defend yourself later from someone accusing you of providing fraudulent dates, which doesn't happen that often, but it's a possibility. And so that's why you'd want to just keep that stuff in your records to be safe.
Okay, very good. Thank you.
Yeah, of course. So yeah, again, if I'm sure there'll be a lot of questions that come up down the road at some point, and like I said, I'm always happy to answer these questions by phone or email. So feel free to reach out to me, and we can chat more about any particular questions you might have or anything you might be trying to do on your own. Like I said, I can help provide some guidance, but I'm also happy to assist with whatever you all might need at any point. So yeah, thank you for sticking around this long. Definitely went a little longer than I expected, but yeah, it seems like everyone got something out of it, and yeah, I'm just happy to provide any other answers you might have.
Very valuable, and I will be in contact with you. Where can we get the slides?
So I will send them to Philip, and then he'll email them to you as a PDF, and then you'll have all this information. And yeah, so there's definitely some things I skimmed over. So you might have follow-up questions, and just let me know, and we can chat more.
So
All right.
yeah, thank you, Justin. And actually, I do want to make a mention. I'm not sure if on Zoom if I have everyone's email address. So if you could please just go ahead and go in the chat, and you can send me a private message for these slides. Just go ahead and send your email in the group chat. It's a private message to me, so no one else has to have your email, and I will go ahead and forward that to you. Justin, also, will it be okay if I share this recording as well?
Yeah, feel free.
Okay. All right. Great. Wonderful. Okay. With that said, I want to thank all the participants for hanging out so late. I thoroughly enjoyed this presentation, Justin. This is really kind of you to stay so late and to dedicate your time to helping us entrepreneurs. And so I really want to thank you for that.
Yeah, no, I'm always happy to help, and yeah, anyone that becomes part of the Cal State Fullerton Startup Incubator, I'm one of the advisors there, so that's another way to get in touch with me is through that program. But yeah, happy to always answer questions though, so just let me know.
Okay.
Very good. Thank you.
Yeah, you're all very welcome.
All right, so I'm going to hang out just for a few minutes and just make sure I get everyone's email address who wants this presentation. Other than that, I'll be logging off, but maybe about 5 minutes. I'm sure if you have something, you can just ask. Justin, you can also do that as well.
Yeah, sounds good. All right, thanks again, everybody.
All right.
This is JJ. I'm going to check out. Thank you, Justin. Take care.
Thanks, JJ. Talk to you soon.
All right.
Okay, I sent my email address to both of you, so thank you very much. I'm going to sign off as well.
All right, have a good night.
Thank you, Hal.
All right, you
good
too.
night.
Bye now.
Hey, hey, Justin, this is Travis. Thank you very much for this presentation. And I was actually thinking about using it in my class later on this semester. You're okay with that?
Yeah, totally.
Yeah, so the way, I mean, with all the changes, basically the way I'm doing things is pre-recording videos and making them available to my students before class. So this is a perfect one for that.
Yeah, no, you're more than welcome to do that for sure.
All right, thank you very much, sir. I'm going to log off now, but we'll be in touch.
All right, sounds good. Look forward to it.
All right, bye.
Bye.
Is Justin still there?
Yeah, I am.
Oh, sorry. I actually had a question, but my audio wasn't working.
Yeah, no worries. What's up?
I hope you can still answer.
course.
Okay, so you mentioned Kickstarter. I kind of have two questions related to that. You said that essentially anything you put on there, it's like free for all if you haven't protected it in any case. Someone could just take it. What measures do we need to do at a minimum? Because, you know, with the Kickstarter, you don't know if it's even worth doing it yet. So
yeah, I mean, that's the tricky thing with those crowdsourcing platforms is, yeah, it's almost like cart before the horse type situation. Sometimes, like you said, you don't know if it's even worth investing any money in if there's not going to be a lot of interest. But I mean, if you want to set yourself up properly, it's better to file an application, a patent application, if it's something potentially patentable before you launch your campaign. And again, at least have a conversation with a patent attorney or a patent agent to see if it's something that's worth pursuing or even potentially patentable, so that you know if that's even an option before you launch. And with that said, I should note, I mean, most attorneys require at least 2 to 4 weeks to prepare and file an application, unless you're going to try to do a provisional yourself. So just give yourself enough runway before launching a Kickstarter campaign if you want to explore those options. But if you want to keep all your options open, as far as internationally and stuff, you want to file before you launch your campaign. And if it's something where you think it's going to be successful, it might be, like I said, if it's like a hard good that might be protectable through design patent, it could be worth filing a design patent as soon as possible and try to get that through even before you launch your campaign, depending on, obviously, I think in most cases, people don't have that much time to sit around waiting for a patent issue before they launch a campaign. But at least get it filed and get it in process so that you can hopefully go after people sooner rather than later. Otherwise, I mean, if it's something where you want to see if there's even going to be a market for it, then you might just launch the campaign first and wait to see. And if it generates enough interest and funding, then you file an application. But again, I mean, you don't have anything, you can't stop somebody until you actually have a patent in hand. You have to have those enforceable rights in hand before you can go after somebody. So that's the trade-off there is, I mean, you run the risk of getting on one of those companies' radars and risking them trying to blitz the market with those knockoffs. So it's, yeah, I mean, it's just kind of the unfortunate reality of the crowdsourcing option. Obviously, it's not the only option, so you would have other ways to try to launch your product. But if you wanted to use Kickstarter, that's just the potential drawback there that just to be aware of. But I mean, I think realistically, it's not like every product that gets on there and gets funded gets knocked off. I mean, it's just the ones that kind of skyrocket, kind of the unexpected successes, if you will, just the ones that ask for, let's say, $20,000 and they're getting like 200,000. I mean, it's those campaigns that typically get cherry picked. But I mean, obviously, you want to be in that group having a product that's that popular. But that's going to be the potential trade-off there is you might have to then ramp up and prepare to start dealing with knockoffs sooner rather than later.
So let's say the knockoffs, they're not even registering it. So is that something where you realize, oh, this is worth it? You find out no one has registered yet, so you're lucky. You register it. Then can you go after people, or is it still already kind of too late?
You can. So, I mean, as long as, let's say, I mean, the timeline's tricky, and not to get too complicated, but I mean, as long as you file your application, your patent application, before any third-party products come out, because if a third party launches their knockoff product, that's going to count as prior art if you have not yet filed your patent application. But hypothetically, if you do your campaign, it's successful enough to justify filing a patent application, you file, and then the knockoffs start coming out. You could go after those knockoffs, but you have to wait until your patent's actually issued. Now, again, I mean, it's all case by case, but there are strategies, as I said, where you can kind of speed up the process. So like you could file a patent application and pay a little extra and request what's called prioritized examination. And you can get a first office action for a utility patent application within about 3 months from filing. So it's going to cost you about $1,000 more in filing fees. But if it's going to get you an office action response and potential allowance in as little as 6 months as compared to 18 to 24 months that you might wait on average for a normal application, not expedited, it could be money well spent to get that patent that much faster and then be able to go after those infringers. So yeah, it's kind of case by case, depends on your budget and everything else. But again, I mean, these are all just, they're good questions to have and to ask. And this should all just be a conversation to have with a patent attorney to figure out what's the best option for you, depending on your budget and everything else, before you actually launch that campaign.
Right. Okay. Thank you.
Yeah, of course.
All right. And is it Han or Han?
Yeah.
One more time.
Yes, Han.
Han, Great. Yeah. And I got your email, so I'll send you a time for us to chat offline.
Okay, thank you.
Yeah, absolutely.
I'm gonna jump off now. All right.
All right. Have a good night.
Okay. Thanks
Good
for
night.
the questions.
Looks like we got Jane and Matt. Oh,
Okay.
they may have just stepped away.
Oh,
Oh,
who's talking, or can I talk?
yeah, you can talk. You
Yeah,
can talk. I just wasn't sure if you
absolutely.
had any questions still.
Oh, okay. Well, first of all, I want to thank you a lot because personally, I wasn't really sure how the trademark worked, but you cleared some questions for me.
Oh, I'm glad. Yeah, and then, yeah, certainly if you have any others, I'm always happy to answer them.
Right. I think a question that I would like to have like noted would be, let's say, for example, I've already taken all the procedures possible to create like different social media platforms,
Uh-huh.
and I'm using that as a form of sharing my intellectual rights.
Mm-hmm.
I'll also be able to share that as me being the rightful owner of what I've been doing this whole time.
Yeah, I mean, it's certainly evidence that you've been using the mark in connection with whatever services you're providing or goods. But yeah, I mean, are you providing goods or services or both?
They're just services.
Services. Yeah, so I mean, you would actually have to provide the services though, and that's going to be the best evidence. I mean, all the marketing materials and stuff certainly help to show like how extensively you're getting your name out there and everything. But it's really, as far as trademark rights go, it's going to come down to primarily like where your customers are, how many customers you've rendered services to, things like that. But marketing, again, especially for like the common law stuff, that certainly factors in. So like if you have hundreds or thousands of users, let's say hypothetically, on these different social media platforms, that certainly shows that your name is getting out there as compared to having just a handful of followers, let's say. So yeah, it's definitely factors into the strength of a trademark, as far as the strength of those rights, at least with respect to the common law stuff. Again, once you get the federal registration, I don't think I mentioned this during my talk, but the courts no longer really care about where your customers are or how extensively you use the mark. It's just if you've got that registration certificate, that's all they care about. And you can then go after people that have come along since you and are using the same or similar name. But yeah, for in the meantime, if you're just focusing on common law rights, then any and all of that is helpful to show or to prove how strong your common law trademark rights are.
Okay. And the certificate can be bought like in the office itself, or is there a fee for it?
The certificate, yeah, there's a fee. So common law rights are free. You don't pay anything. They're just arise automatically by virtue of you using the mark in commerce, or sorry, in commerce generally. Once you start doing business across state lines and you're eligible to receive that federal registration certificate, that's where there is a fee. So you would pay a filing fee to the trademark office, and that basically compensates them for the time they'll spend examining your application and issuing the registration certificate and everything. And then if you have an attorney assist you, there would be a small fee that you would pay them as well, to help you prepare and file that application. But yeah, there would be costs involved for a federal trademark registration, and the costs vary depending on like how many goods and services you're offering. So if that is ever something of interest to you, you can just reach out to me by phone or email, and we can talk further about what all it is you're doing under the mark, and then I can kind of better figure out what the filing fees would be and everything else for your particular case.
Okay.
Yeah.
Very much. I'll stay in touch then.
Okay.
Okay. Have a nice night.
Thank you. You too.
Yeah, thanks for joining us. Matt, did you have any other questions?
I think I put Matt to sleep.
That's okay. It's probably that time.
Yeah, yeah.
All right. Well, if there's anybody else who wants the recording, Jane or Matt, please send me your email. If not, I'll go ahead and conclude this.